March 12, 2026. A legal filing lands simultaneously at the UK Crown Property Commission in London and the California Superior Court in Santa Barbara. It has been prepared by celebrity attorney Cher Tilden, filed on behalf of her client, and it concerns a 72-acre estate in the Cotswolds called Renbrook Hill. The filing arrives precisely 72 hours after the palace issued the most sweeping declaration it had produced in a generation, stripping the Sussex family of all remaining royal privileges, legal honors, and custodial rights in a single document whose language was, by the standards of palace communications, almost brutally direct. Renbrook Hill is not an ordinary piece of land. It is a Grade 2 listed Georgian manor house sitting at the center of a heritage estate that includes a royal-funded equestrian center and multiple vineyard parcels. It was originally part of the Highgrove West Sector Elizabeth II territory, in the precise sense that her personal designation shaped every decision about what would happen to it. A 2025 valuation placed its worth at £19.6 million. It is, by any measure, one of the most coveted unassigned royal properties outside of Balmoral and Sandringham. And as of 9:14 on this particular Thursday morning, Meghan Markle's legal team is claiming that it belongs to her. The basis of the claim, as Tilden's filing sets out, is a verbal commitment made by the late Queen Elizabeth II prior to 2021. An oral designation of Renbrook Hill as a marital residence and future inheritance for Prince Harry and his direct family. My client intends to exercise her lawful and equitable interest in the estate known as Renbrook Hill, the statement reads. It was promised as a family legacy, not an instrument of punishment in divorce proceedings. The language is careful. The implication is enormous. And the timing 72 hours after a declaration that removed every remaining institutional protection the Sussexes had been operating under is not a coincidence that anyone with knowledge of how these legal operations work would believe was unintentional. Within 3 hours of the filing going public, the palace issued a rare midday statement through the Office of the Royal Legal Secretary. The language was unequivocal and entirely devoid of the diplomatic softening that palace communications usually apply to sensitive matters involving family members. No formal or informal commitment was made to transfer Renbrook Hill or any part thereof to the Duchess of Sussex. The property remains under the stewardship of the Royal Estates Office as a Class A Crown Trust asset subject to sovereign directive. Royal legal advisor Sir Alaric Mansfield went further. Any verbal assurances given before 2021 were nullified by the couple's departure from royal duties in January 2020 and explicitly extinguished under the revised Sovereign Property Charter enacted in March. Behind those formal statements, inside the palace's operational circles, the assessment of what the filing actually represented was considerably less restrained. Multiple royal aides, speaking in the particular shorthand of people who have been watching this story unfold across years and have finally reached a point of exhausted clarity, converged on a single characterization. She is not asking for a home. One royal insider said it plainly. She is trying to requalify herself as part of the royal apparatus by proxy. By asserting property rights linked to Harry, she was attempting to position herself as a co-beneficiary of ancestral assets, and in doing so, to challenge the institutional custody arrangement that had just been established, using an estate claim as the legal lever. The California Superior Court sent its own early signal. Royal property claims would not be admissible in custody matters unless formally recognized by both the UK Privy Council and His Majesty's Diplomatic Property Register. The message from both jurisdictions was identical in its logic, if not its language. A claim to land was not a claim to children. The question was whether the filing was primarily about the land at all. It was not. And what followed across the next 3 weeks would make that clear beyond any reasonable interpretation, not just through the legal filings and counterfilings and platform directives and sealed courtroom depositions, but through the specific and cumulative weight of every decision made and every statement issued and every photograph released, until the shape of what was happening became visible to anyone paying attention. This is the story of how the Sussex era ended. Not with a single dramatic moment, but with the inexorable logic of a legal and institutional machinery that had been set in motion and could not be stopped by voice memos or defamation threats or the specific brand of emotional leverage that had worked in various configurations for years. It ended with a ruling delivered simultaneously in 2 courtrooms on 2 continents, each one arriving at the same conclusion through a different legal framework but pointing in the same direction with the same finality. And it ended with a man carrying a Paddington Bear toy through a private terminal at Heathrow, headed somewhere he had not been able to go without conflict for a very long time. The filing that arrived at 9:14 on a Thursday morning in March was the last move. What the palace did in response was not a counter-move, it was a conclusion. To understand why Renbrook Hill was chosen as the specific instrument of this particular legal strategy, you have to understand what the estate represents within the architecture of the royal family's relationship to its own past. It was Elizabeth II's designation, her personal and deliberate act of setting something aside in a sealed letter of intention dated 2020 for Prince Harry and his direct family. That letter established Harry as preliminary trustee of the estate, holding it in reserve for future lineage planning. The formal trusteeship was never enacted because, less than 3 months after the letter was written, Harry and Meghan departed from royal duties in January 2020 and relocated first to Canada and then to California. The estate moved into inactive trust under the Duchy of Cornwall, its formal future deferred indefinitely. For 5 years, Renbrook Hill had sat in that administrative limbo occasionally used by senior royals during hunting season, its larger designation neither confirmed nor explicitly revoked. In October 2025, Princess Anne had reportedly raised the possibility of reassigning it to Lady Louise Windsor under the newly established Sovereign Youth Development Charter, but no official reassignment had been made by the time Meghan's filing arrived. The timing of that filing was therefore not accidental in another dimension as well. It arrived at precisely the moment when the estate's future was most uncertain and most contested, the specific window in which a claim, however legally fragile, might create enough jurisdictional ambiguity to complicate the palace's ability to proceed with other plans. The palace's legal response, coordinated through Sir Alaric Mansfield's office, was swift and definitive. The revised Sovereign Property Charter of 2023 had been written partly in anticipation of exactly this kind of challenge, a document designed to close the gaps in the pre-2020 arrangements that had left certain royal-adjacent property questions in a state of interpretive openness. Any verbal assurance given before the departure the charter established was extinguished by the departure itself. The oral commitment in Elizabeth's sealed letter, whatever its moral weight, had no legal enforceability in the absence of the formal trusteeship that had never been executed. The claim to Renbrook Hill was legally unviable. What it remained was strategically revealing. As Dr. Henrietta Accuses, a legal scholar who had advised on transnational family disputes, observed at the time, the California court is signaling that royal property claims do not automatically equate to parental competency. This undermines any narrative where the estate is being used to appear institutionally validated. While the Renbrook Hill filing was generating its headlines, the more consequential legal battle was unfolding in the financial disclosure process that the divorce proceedings had activated. Royal accountants operating under the authority of Princess Anne's Office for Sovereign Integrity released a comprehensive asset breakdown that assembled, for the first time in a single public document, the full picture of what the Sussex financial architecture actually contained. The Montecito Mansion, assessed at $14.2 million, 2 Rolls-Royce Cullinans leased under Archewell, a Range Rover autobiography, a personal gift from Charles in 2019, liquid holdings estimated at $4.7 million in cash, and low-risk investments. Jointly held stock in Archewell Media at 33% under Meghan's name, and a 16% stake in Archewell Audio following the Spotify exit. Against these assets, business debts exceeding $2.3 million, primarily linked to Meghan's wardrobe, PR campaigns, and Dubai brand travel between 2023 and 2025. Meghan's legal team demanded a 50-50 split of all domestically acquired marital assets, citing California community property law. The palace pushed back sharply. Multiple acquisitions were either sovereign gifts or trust-based allotments tied to Harry's royal status, and were therefore not subject to California community property provisions. She cannot both reject the crown and claim its privileges. Sir Alaric Mansfield's formulation was blunt. The monarchy is not a vending machine of wealth for former duchesses. The alimony demand was, if anything, more combustible. Meghan's filing requested $215,000 per month for a period of 5 years, citing career sacrifices and public reputation damage caused by the royal institutional machinery. Harry's legal team, led by Miles Armitage, responded with a dossier whose contents made the alimony request almost impossible to sustain. The dossier included a waiver Meghan had signed in July 2020, a document in which she relinquished future claims to royal subsidies in exchange for branding freedom, and evidence of $6.1 million in unreported income from a 2023 Dubai speaking tour and associated private sponsorship deals. Armitage's supplemental statement was not diplomatic. You cannot claim victimhood while profiting from the platform. Alimony is for caretakers, not entrepreneurs in heels. The child support counter-motion escalated things further. Meghan rejected Harry's proposed $68,000 monthly provision for Archie and Lilibet's educational, medical, and living expenses, and instead demanded $22,000 per month contingent on direct invoice documentation for every expense, with a provision that no extracurriculars could proceed unless pre-approved. The demand that attracted the most immediate and intense reaction, however, was the last: full access to and sole control of the children's digital image rights, including Instagram management and potential publishing projects involving their likenesses. The Royal Child Welfare Committee responded with a new clause, effective immediately. No commercial use of Archie and Lilibet's names or likenesses could proceed without dual consent from the Crown and from Prince Harry. The palace had, in a single administrative action, made the demand legally impossible to satisfy unilaterally. What the financial disclosure process also surfaced was a document that Meghan's legal team had not anticipated being recovered. A sealed brand deck, labeled Project Emancipation and dated May 2025, in which her team had laid out detailed plans to monetize her identity as a post-royal, post-maternal figure in global wellness markets, a brand architecture that specifically excluded her children from its public image. The document directly contradicted the legal narrative her team was currently presenting in court, that she had sacrificed personal and professional opportunity to nurture her family and deserved compensation for those sacrifices. Both courts were briefed on its existence. The contradiction was not arguable. Public opinion, in the specific sense that polling attempts to capture it, had been moving steadily against the position Meghan's legal team was constructing. A flash poll published by the Daily Mirror on March 14, 2026, found that 74% of UK respondents opposed the estate claim. 61% of US respondents believed she should receive no alimony. 82% supported Harry retaining primary custodial guardianship under institutional supervision. These were not numbers that a communication strategy could easily reverse, particularly when the corporate sector was simultaneously conducting its own assessment. Vogue Arabia, which had been planning a cover featuring Meghan under the headline "Mother, Mogul, Monarch," quietly withdrew the project. Chanel rescinded her invitation to Paris Fashion Week without public explanation. Netflix suspended all in-development Sussex-related projects, citing contractual instability and reputational risk. The commercial infrastructure that had been providing the Sussex brand with its post-royal revenue base was recalibrating, and it was recalibrating in the direction that the polling, the legal filings, and the palace's formal positions had been pointing for weeks. Into that atmosphere, Princess Catherine made a statement. not through a formal press release or a palace communication, but through the register of language that she had developed over years of public engagement, the register that is soft in its delivery and precise in its targeting. Speaking about the protection of children in public life, she said, "Children are not branding tools. They are not passports to power. They deserve privacy, protection, and peace." The words were framed in general terms. They were not accompanied by any name or any direct attribution, and everyone who heard them understood exactly who they were aimed at. The response across social media and in the press coverage that followed was immediate and almost entirely supportive. It was the kind of statement that is most effective precisely because of what it doesn't say. Stripped of institutional backing, her property claim categorically denied, her financial demands under active legal challenge, the Project Emancipation brand deck in the hands of both courts, and her commercial support structure visibly contracting by the day, Meghan's legal team made a decision that royal insiders and legal analysts alike would subsequently describe as the move that definitively ended whatever residual public sympathy her position had retained. They had run the strategic playbook from the beginning of the proceedings, the property claim as institutional leverage, the alimony request as evidence of victimhood, the child support countermotion as a demonstration of maternal engagement, and each element had been met with a response that neutralized it. What remained, when the institutional and financial and property arguments had all failed to shift the trajectory of the proceedings, was the personal. And the personal move they chose was the one that Miles Armitage would later characterize, with an economy that said everything it needed to say as weaponized desperation cloaked in concern. In a surprise filing with the Santa Barbara Family Law Court on March 16, 2026, Meghan's team submitted a sealed 32-page declaration accusing Prince Harry of historical patterns of emotional volatility, alcohol dependency, and coercive behavior during their marriage. The document included a psychiatric assessment from February 2021 identifying signs of untreated PTSD and unresolved anger, 2 therapy session summaries from 2022 that Meghan claimed had been triggered by verbal outbursts witnessed by household staff, and a statement from an unnamed security consultant asserting that Harry had thrown a mobile phone against a wall during a May 2023 argument about Archie's school transfer. None of these documents had been independently verified. The filing requested the immediate suspension of Harry's custodial authority until a court-appointed psychological evaluator completed a new assessment. The palace's rebuttal arrived with unusual speed. Harry had successfully completed a therapy program at the Royal Veterans Mental Wellness Clinic in mid-2021. He had passed all family counseling reviews associated with the 2024 Royal Reconciliation Framework under Princess Anne's oversight. He had maintained a consistent, clean record of supervised parental conduct since December 2025. Harry's attorney characterized the new filing in plain terms. The Crown does not assign custodial authority lightly. These are not emotional endorsements. They are legal designations grounded in behavior, stability, and consistency. His counter-declaration included audio logs from 3 child welfare mediators who had overseen Harry's video sessions with Archie and Lilibet between November 2025 and January 2026. All 3 of whom attested to his positive engagement, emotional attentiveness, and consistent deference to professional guidance. Meghan simultaneously filed an appeal with the Court of International Family Law Cooperation, arguing that royal guardianship protocols could not supersede a biological mother's rights under U.S. federal law. Her team cited the primacy of maternal preference in early childhood custody rulings under U.S. precedent, the inadmissibility of foreign ceremonial titles as legal authority in California, and what they described as the coercive power of inherited royal structures in producing unfair legal outcomes. The palace's response was the signed 2020 Sussex Marital Compact, a document co-signed by the late Queen's legal secretary and 2 Foreign Office officers establishing that both Harry and Meghan had agreed to custodial oversight by the Crown in the event of international relocation or marital separation. The compact was enforceable under the Royal Heirs Treaty of 2017, reaffirmed post-Brexit. Legal scholars confirmed its enforceability, and it emerged in the course of the court's examination that Meghan had attended 3 of the 4 drafting meetings and had herself suggested revisions to the document. One California official was overheard in the courthouse corridor with a characterization that circulated widely. If this was coercion, it was highly organized and extremely well-litigated coercion by her own counsel. While the legal filings were accumulating in the 2 court systems, the palace was executing a parallel operation that its internal communications described as crisis containment. What sources inside the institution were calling the Windsor firewall was a coordinated action across the digital, financial, and symbolic dimensions of the Sussex brand's remaining infrastructure designed to accomplish in a compressed time frame what years of restraint and diplomatic patience had failed to produce. At 6:30 inches the morning on March 17, 2026, the Royal Office of Digital Ethics, operating in conjunction with the Privy Council's Communications Wing, issued a classified directive to more than 22 platform partners, YouTube, Instagram, Meta, Spotify, and Netflix among them. The directive demanded the removal or reclassification of all Sussex-branded content hosted on Crown-affiliated archives, the immediate disassociation of the Windsor children's names and images from any non-authorized digital usage, and a freeze on algorithmic amplification of Archewell-linked legacy content still indexed under royal tags. The legal justification cited Article 9 of the Sovereign Identity Preservation Act, enacted in 2023 following the Queen's passing, which granted the Crown emergency authority to protect minor heirs from non-consensual commercial exposure. By noon that day, more than 380 pieces of content had been flagged, tagged, or demonetized across streaming and social platforms. Sussex material that had dominated royal search algorithms for years began quietly vanishing. Simultaneously, the UK Charities Commission announced the beginning of formal dissolution proceedings against the Archewell Foundation. The commission cited 3 primary failures: non-compliance with bilateral financial disclosure protocols under the Royal Charity Ethics Compact of 2021, suspected misclassification of foreign income tied to Meghan's Dubai wellness tour, and irregularities in staff salary disbursements between 2022 and 2024. The Archewell brand, once the flagship of the post-royal Sussex enterprise, now faced a multi-jurisdictional audit and the freezing of residual assets across 2 trust funds. Meghan's email credentials, server access history, and trademark claims were transferred to the Crown's Digital Accountability Tribunal, chaired by Lord Julian Ashcroft. The most symbolically charged confrontation of the firewall operation arrived when Meghan filed a digital ownership motion demanding sole control of the joint Instagram account that had been established for the children. She characterized it as a maternal project founded for narrative balance. Harry's legal team responded in a single sentence: "This is not a brand. These are children." Meta's global legal team, citing conflicting claims involving minors and sovereign classification, suspended the account indefinitely. The account with its millions of followers went dark. No announcement. No final post, simply gone. While the press tracked every legal filing and platform removal and corporate withdrawal, a quieter but in many ways more significant development was unfolding inside Windsor. Lady Louise Windsor, 22 years old, had been quietly elevated by Princess Anne to serve as royal youth liaison to the heirs of Sussex, a role that had been created specifically for this moment and that reflected both Louise's personal connection to the children and the palace's understanding that the legal machinery, however necessary, could not by itself provide what Archie and Lilibet actually needed. Louise had formed a quiet bond with Lilibet during summer visits to Balmoral in 2023 and 2024. She was not there to raise the children, one courtier clarified carefully. She was there to anchor them to ensure that in the middle of a conflict whose scale and visibility far exceeded anything a 7- and 5-year-old could be expected to process, there was a consistent, warm, non-institutional presence that connected them to something stable. She arrived at the Royal Learning Center at Sandringham carrying books, child therapy kits, and a copy of The Little Prince, which was reportedly Lilibet's favorite story. There were no cameras, no press release, no statement. Princess Catherine's public gesture, by contrast, was calibrated for maximum reach with minimum words. During a visit to the Royal Digital Ethics Institute on March 18th, she delivered a short keynote address on the protection of childhood in the age of exploitation. The words were framed in general terms. No names were used. "We live in an era," she said, "where a child's likeness can become currency. That is not parenting, that is projection, and projection is not love." The audience, cybersecurity experts, and youth welfare leaders gave a standing ovation that was not entirely about the speech's formal content. Later that day, Kensington Palace released a photograph. Catherine with Charlotte, George, and Louise reading together under a tree. No branding, no staging. No caption beyond 4 words: "Let children be children." Meghan's response arrived that same evening, distributed as a voice memo to multiple media outlets. "If they erase me," she said, "I'll expose them. I have emails, recordings, names. Don't push me out of my children's story." The statement was the kind that is issued when the strategic options have narrowed to the point where the only remaining move is threat. It landed with the specific quality of a threat that the people it was directed at had already prepared for and were no longer afraid of. Spotify delisted all Sussex-related podcasts within 48 hours. Netflix issued a formal termination notice. Princess Anne replaced Meghan on the cover of L'International, the headline reading, "The New Face of Leadership Without Noise." 2 parallel legal chambers opened their doors behind sealed curtains in the final week of March 2026. In London, the family division of the High Court, presided over by Justice Rowena Blackstone, known for her uncompromising application of constitutional precedent, and for a judicial temperament that her colleagues described as constitutionally allergic to sentimentality, took up the UK dimension of the custody matter. In California, Santa Barbara Superior Court, with Judge Everett Miles presiding, addressed the American dimension. Both courts were operating under the Windsor, California Reciprocal Protection Accord of 2024, a transnational legal framework that had been established specifically to provide shared jurisdiction over royal minors holding dual citizenship, and whose existence had been a matter of limited public knowledge until the Sussex proceedings brought it into the foreground of international legal commentary. The private depositions that shaped the atmosphere in both chambers were not the expert legal arguments or the formal submissions of competing counsel. They were the testimonies of 4 individuals with direct knowledge of the children's actual lives. Lady Geneva Hartley, the Royal Child Welfare Observer, testified to Meghan's non-compliance with child welfare check-in protocols since late 2025. Dr. Angela DeLay, a child psychologist who had conducted supervised interviews with Lilibet in January, reported signs of emotional stress and behavioral confusion that she attributed to the instability of the child's living situation. Caleb Wren, a former Archewell operations officer, confirmed that Meghan had actively suppressed Harry's input in decisions about the children's education and media presence. And Lady Louise Windsor, acting as liaison to the children, shared a written journal documenting Lilibet's recurring question across multiple sessions. "Why do I only see mommy on camera?" That question, 6 words from a 5-year-old, reportedly shifted the atmosphere in both courtrooms in a way that no legal argument had managed to achieve. The abstract questions of jurisdictional authority and the enforceability of royal compact language gave way, in the rooms where the actual decisions were being made, to the pressing and entirely concrete reality of 2 children whose daily experience was being shaped by a conflict they had no capacity to understand. The marital compact proved difficult for Meghan's team to overturn. They could not demonstrate that she had been excluded from its drafting. She had attended 3 of the 4 sessions and had herself proposed revisions. They could not establish coercion in any legally operative sense. The arguments that had been framed as about institutional power versus maternal right were being heard by courts that were focused, with increasing directness, on the question of what was actually happening to the children. The coordinated rulings arrived within hours of each other in the first days of April 2026. In California, Judge Everett Miles was direct. Given the cross-jurisdictional provisions and the sovereign framework agreed to by both parties in 2020, this court recognizes the Crown-appointed guardianship structure as valid and enforceable within U.S. bounds. In London, Justice Rowena Blackstone echoed the logic from the British constitutional side. Under the Royal Minor Protections Act, and in light of verifiable endangerment of minor privacy, the Crown assumes direct custodial oversight in partnership with the biological father, Prince Henry. The mother, Meghan Markle, is hereby suspended from sole custodial decision-making for a period of 5 years, pending psychological review and compliance with institutional protocols. The practical structure of what was established: joint institutional custody between Prince Harry and the Crown, with Princess Catherine serving as day-to-day educational and domestic guardian and Duchess Sophie of Edinburgh as liaison for external affairs. The arrangement was not presented as punitive. It was presented, in the language of both rulings, as the framework most consistent with the children's documented welfare needs and most likely to provide the stability and protection from commercial exploitation that the proceedings had identified as the primary risk to their well-being. Meghan's parental access was defined in terms that represented an almost total reversal of what she had been seeking in court, and a reversal that was given the testimonies of the child welfare observers, the mediators, and the liaison who had recorded Lilibet's recurring question about why she only saw her mother on camera, difficult to characterize as anything other than proportionate to the documented situation. One supervised video call per week through child welfare mediators, in-person visitation once per quarter at a neutral UK-based location, not at any royal estate. No legal authority to enroll the children in schools, authorize media appearances, or make travel decisions. The court cited commercial endangerment and repeated disregard for institutional custodial frameworks as the primary justifications for the restrictions imposed. In a separate ruling from the Court of Royal Titles and Privileges, a rarely convened advisory council established in 1831, Meghan was permanently barred from using any Windsor-related designation in commercial, philanthropic, or political activities. All variations of Duchess of Sussex, any reference to the royal foundation of the Duke and Duchess of Sussex, any product or campaign that referenced the children's royal titles without prior Crown consent, all of it foreclosed. The Charities Commission concluded its Archewell Foundation investigation with a determination of dissolution, financial misrepresentation, foreign lobbying entanglements, and brand misuse. The foundation's final reported balance of £1.7 million in unrestricted assets was redistributed to 2 children's welfare charities selected by Princess Anne. The Sussex era, as a legal and institutional category, had ceased to exist. Harry was seen leaving a private terminal at Heathrow on an April morning. No cameras had been tipped, there was no press waiting, no entourage, no stage departure. He was wearing a plain black coat and carrying a canvas bag, and in his hand, held with the specific unself-consciousness of someone who has stopped worrying about how things look, was a small Paddington Bear toy. He was not heading to Montecito. He was heading to Wolverton Cottage, designated as the transitional residence for Archie and Lilibet, where Princess Anne had been reviewing their 2026 to 2027 education plans, and where Lady Louise had prepared a short film compilation of Lilibet's time at the Royal Youth Retreat for him to watch with her. One aide described what followed as not a homecoming, but the beginning of a reckoning he chose. Back in California, Meghan remained visibly absent from the spaces she had inhabited for years. Her last photographed appearance at a Brentwood cafe was described by those present as drawn and disconnected, the specific quality of someone who has been moving very fast for a very long time and has stopped and is now sitting with the stillness of someone who no longer knows where to go next. The Netflix production deal had been officially canceled. The Spotify renewal clause was voided. The Dior endorsement was quietly terminated. Paris Fashion Week had replaced her scheduled guest segment with Lady Louise Windsor, promoting, In the language of the event's communications team, resilience and royalism. Her PR agency's internal assessment, leaked to a British outlet on April 5, 2026, was as bleak as any institutional postmortem produced in the course of this entire story. It was the assessment of a team that had been managing a brand under extreme conditions for years and had reached the point of professional honesty that teams reach when the gap between the public narrative and the operational reality becomes too wide to bridge with any strategy that a communications firm can provide. We cannot rebuild, the memo read, while litigation, institutional bans, and custody failures dominate the narrative. We must go dark, and she did. All social media went silent. Her website redirected to a static page. No new interviews were scheduled, no appeals were filed, no voice memos were released to media outlets. For the first time in years, Meghan Markle was not trending. She had simply, quietly stopped. Princess Anne delivered the final institutional statement from Sandringham in a press release that was, in its economy and its precision, exactly what the moment required. The matter has closed. The children are safe. The future is guarded by principle, not power. We do not erase, we protect. We do not retaliate, we recover. May this silence serve the best interests of those who deserve peace most. That evening, Catherine was photographed at a children's hospice, placing a handwritten note beside a teddy bear on a windowsill. The note read, "For every child who felt watched, let them now feel seen with love, not strategy." The House of Windsor, shaken by years of attrition and spectacle, and the specific kind of institutional damage that comes from a conflict conducted simultaneously in courtrooms and media cycles and social platforms, had reasserted the doctrine that its most enduring figures had always embodied when the pressure was at its highest. Duty before drama, protection over profit, legacy before ego. Meghan Markle's name would not vanish from history. But her royal story had reached its institutional endpoint not with a dramatic final act, not with the explosive revelations she had threatened to produce, but with a silence that descended gradually and then completely, in the way that silences do when there is simply nothing left to say that any court or platform or audience is prepared to hear. And for Harry, the final chapter remained unwritten. But for the first time in years, it would be written not on camera, not under the management of a brand operation, not in the middle of a legal war. It would be written in a cottage in the English countryside with two children who needed him to simply be their father. Not a duke, not a brand partner, not a casualty or a combatant. A father. And that, in the end, was the only title that was going to matter.